Welcome everyone. My name is Bobby Fazy. I'm president of Insight Law, and the name of this session is Family Training Session Part 2, What to Do When a Loved One Passes Away. So if you're attending this session, you're either a client or a helper of a client or a beneficiary. And those who are attending the live webinar, you have been emailed in advance a helper's handbook through PDF. This helper's handbook is also located on the website for our clients and their helpers. And so we will be referring to that during this program. So the first thing I wanted to show you with regard to the helper's handbook, how it's organized, is we found that our clients like a little cheat sheet at the beginning as far as if someone does pass away, what are the absolute do's and don'ts that the family members need to know about. And then as far as how the binder is organized, we have the first session, the training session 1 is what to do when a loved one is ill, that we've covered, and that is on our website. And those apply, or we go into the first 4 tabs during that program. For this program, we're going to really focus on tabs 5 through 10 and go through that. Actually, tab 5 is where the outline is for this program. And so if you'd like to follow along on the PDF, that's the way to do it. But also, we've got the PowerPoint that's on the screen as well. So with that being said, we're going to start the program. And so the majority of our clients employ the use of a trust during their lifetime, and those provide really powerful planning techniques, makes the administration go a lot smoother. And so after a person passes away, the process of winding down of affairs begins. And what we call that in the legal profession is either trust settlement or trust administration. So that's what we're really going to focus on today. Things to do when something does happen. If a loved one passes away, do call the law firm immediately. We have a specific process in place. We have got the instructions, and we know what to do at that time. But this meeting is important that you understand how the process actually works. Do know where the red and white books are. We could give you a little bit of background. All of the legal documents when it comes to in our estate planning firm, the legal documents like the trust, medical directives, and power over wills, those types of legal documents are located in our client's red binder. We also have what's called a white binder or white client organizer that has a lot of the checklists and that the clients use. So if there's a disability, we have healthcare checklists, but also final arrangement checklists. So if you're following along in the binder or the helper's handbook, you'll see that the final arrangements checklists are behind tab 6. And I've given a blank final arrangements checklist here. So this we find has been saved a lot of time for the family. It takes a little pressure off the family as well. So you can list on what family relatives or family members or people that you want to notify. You can also, in the alternative, lay out the people that you don't want to notify as well, have notified. If you want to have an obituary, the information that would be put in the obituary could be listed there as well. If you wanted to be buried or cremated, or if you wanted to be like Ted Williams and have your head frozen cryogenically, you could do that as well. That is all laid out in these final arrangements. I belong to a national network, or our firm is part of a national network of estate planning attorneys. We did not develop this checklist. This was actually developed by the chairman, Rick Randall, and also a funeral director. And we really feel it's comprehensive, and it covers a lot of the issues. And we found from other families members that they have really thanked us for this. The last thing that I want is you've taken the time to go through these final arrangements, make specific plans. If you did do pre-planned funeral arrangements, but those wishes are not honored if the family members don't find those final arrangements. So that's one of the immediate items that we want to make sure that is covered. Do arrange for the immediate care of pets, and do secure the house. And what I mean by securing the house is a couple of issues. One, if it's, sometimes we're doing this program in March, and we've had some really tough weather this year, and so make sure that the house is winterized, the plumbing checked. Other items like maybe keys or access to the house have been given to housekeepers or landscapers. We want to make sure that the house is secure so there's no issue of furnishings and items kind of walking away or leaving the premises. We don't want to have any unnecessary issues if we don't have to. Do schedule a settlement conference with the law firm within 2 weeks. So obviously, if the death occurs, your family is going to be put on a priority, and we will get you in here. My calendar books up 2 months out, 3 months out, but this would be a priority, and we would clear the schedule to make that settlement conference happen. Do make a list of questions. I find that as time goes by, you may have one question here, one question there. Just make sure that you write those down. For some reason, invariably, if you come into the settlement conference room, a lot of times the family members or the helpers forget the questions. So we want to make sure that we can answer your questions, give you peace of mind. So do write them down as well. Okay, things not to do. Do not race down to the bank and close the accounts. The days are over where the bank will freeze accounts. We have our approach is to create trusts, and we have trustees that can have access to the account very quickly. We can fax or email the banks, and so do not worry about that aspect of it. Don't roll over any IRAs, 401ks, or qualified plans. There are a lot of issues to be considering these days with qualified plans, is what I call them, or the IRAs or 401ks. And so there's different strategies that you can employ. And what we want to do is to make sure that you know all of your legal options before you do any rollovers. If you have a financial advisor as well, we want to make sure the financial advisor is on the same page and that we all put our opinions in and that you make the best decision based off of what your advisors have to say at that point in time and what the laws are at that time, because they're changing as well. Do not drive the decedent's automobile. And so think about this one is the car is in the decedent's name, and we spend a lot, we take time and make sure that our clients' plans are structured so that if there is a death, that we can provide some significant protections. We call them school bus protections if the beneficiaries were to hit a school bus and have creditors. But the idea is that we have built all these protections in, but if you drive the decedent's automobile, and let's say you get into an accident and kill somebody, the decedent's name is on the automobile or it's in their trust, that is going to subject the estate that we put all these protections in. It could destroy all of those protections and take away all of those assets. So we can very quickly get the decedent's auto out of their individual name, or if it's in a trust at that point in time, you can get that out quickly. And so just make sure that you don't do that. Don't remove any household furnishings. We have a specific process to do that, and we don't want to have any hurt feelings or hard feelings between family members. We've taken a lot of time. Our clients have taken time, and they're doing the planning because they care about their families, and we're trying to make life a little bit easier for the family during a difficult time. Hate to see anything happen as far as certain specific items are not inventoried properly. So we want to make sure that we have a good inventory, and then anything that clients instructed us to do, their wishes are honored, and then the furnishings get distributed out to the appropriate parties. Don't pay any bills for 2 to 4 weeks. Well, ask for 2 to 4 week extensions. Death occurs. A lot of times we can negotiate debts and the like. So the creditors can wait. If the funeral home wants some type of payment, we can get the bank accounts to the trustees in time, or at least provide some type of verification to the funeral home, knowing that there is sufficient assets to pay their bill. Don't use the decedent's credit card. That is fraud. When someone passes away, their credit card, you can't use their credit card afterwards. So we hate to see any type of legal issue with you. So don't use the decedent's credit card after the loved one passes away. Don't contact any life insurance and annuity companies. Again, similar to qualified plans and IRAs, there are a lot of different options that you can employ. So we want to make sure that you understand all of your legal options. If you're a financial advisor, make sure that we collaborate and then make the best decision for you. There could be different settlement options like lifetime payouts, lump sum payouts, payouts to certain accounts. So we just want to make sure that you considered all of your options beforehand. Don't use any powers of attorneys. Similar to the credit card, powers of attorneys are void after you pass away, and it is considered fraud. The powers of attorneys are legal documents that appoint agents the ability to manage assets during disability situations. But after death, the power of attorney dies with you. Okay? Settlement conference. To give you an idea of what the settlement conference agenda looks like, first of all, we want to make sure that, like I said before, that you bring a written list of questions if you have any questions. Hate to have a question that you thought about but forgot to do it, so we want to go ahead and address that, make sure that your concerns are addressed and answer them. We will, before the meeting, we'll send you a list of documents so that you are prepared for the meeting, or at least bring the documents in. A lot of times it's recent statements and utilities and debts and expenses, those types of documents. Ethical guidelines only require that I can only meet with the trustees and named beneficiaries in the trust for the initial settlement conference. It's not that we're trying to exclude spouses and other people, but for legal purposes on the initial settlement, I can only meet with the named trustees and the beneficiaries. And at that point, if they just determine or they would want to waive that right, then we could have an authorization signed so that they can access, or they could come to the future meetings. Okay, we would go over at the conference, or the settlement conference, we would do an overview of how the plan works. We would review our settlement process. We find that in our firm, that process produces predictable results. So not only do we have a process to set up the plan, to maintain the plan, but we also have a settlement process to settle the plan. Discuss possible tax planning strategies. Many people think that the tax planning strategies are gone after someone passes away. That's simply not true. There's a lot of different options that you can employ and strategies afterwards as well. We would be delegating tasks on who's doing what. We would manage the process, but we want to make sure that it's a team approach and that works out where it becomes most efficient for all parties involved. We will establish timetables. And so to give you an idea, and often a very common question that we receive is, when can we receive the funds? And so the majority of the trust settlement administration work at our firm is done in the first 3 months of the planning, the first 90 days. But for purposes like tax purposes, we would need to wait at least 6 months for what's called an alternate valuation date. And that could impact taxes. Think about the stock market that could be volatile, where stocks go up and down. We could maybe, if 6 months later, stock values that might be higher or lower, that could maybe provide some benefit for the beneficiaries on the tax side of things. We would address any questions and fees. And so I'm going to go into a little bit on fees right now so that you understand our process, because most people think estate planning is you set up your original legal documents and that's basically it as far as the fees, but there are other fees that are involved. And so I'm going to reference you to your helper's handbook. And if you go behind a tab Tab 7, okay, right before the trust settlement instructions, we have the investment selector. And so the estate planning fees, think about it this way. You have the cost of setting up the plan, or the cost of the initial documents and counseling, the cost of maintaining the plan, and the cost of settlement. And our clients have chosen, after we set up the plan, to maintain the plan with us. And so you wouldn't be listening to this program if you weren't on our maintenance plan. And there is a renewal fee currently at $595. We have different clients come in at different points of our different points of the firm. Currently, it's at $595 a year, and that fee is used to defray some of the costs of programs like this that we do for education training purposes, updating legal documents, educating the family, and maintaining the funding, making sure the assets are titled properly. Those things that we do during our lifetime and being proactive, we're able to actually do the settlement at, we were able to cap our settlement administration fee. So we charge a flat fee. Currently, it's 1.25% on the size of the estate of the deceased client. And so that number that's the current number, depending exactly, again, when you came into the firm. We have those agreements that are in place where we cap those fees. Just to give you an idea of what the market is, or published guidelines in the local courts, those administration expenses can range anywhere from 2 to 5%. So that is the majority of our clients. We call this the fixed fee option, and the majority of our clients are on this option. Some people have opted to take the variable option, where they paid a little bit less upfront, but on the settlement and administration, we charge about 2%. And the first tax coupon currently is $5,430,000, but that number continues to increase because it's indexed for inflation. So that just gives you an idea of how the process works as far as the fees are concerned. The practice evolver that's on the next page is very, it's very simple. This is what I say. This page is what's in it for the clients, what's in it for you. This is what's in it for the firm. We try to be very transparent and disclose all of the fees in advance, and really what the settlement and administration, pretty much the situation is that we have maintained the relationship with our clients, and that provides a really nice succession plan for the law firm, where internally we have relationships with the clients, and we will be there when the family needs us most. Okay, so after we address questions and regarding address any questions and go through the fees, we sign engagement letters, and then we will go over how the trust works. So the overview of how the plan works, think of it this way. There's 3 main time periods in someone's life: when you're alive and healthy, when there's a disability, a mental disability as opposed to a physical disability, and demise or death. Okay. Let me just do one thing here. Apologize. Just getting our programming straight. Okay, so think of, like I said before, the revocable living trust. I'm a big visual learner, and we just think of the trust while you're alive and well, or clients are alive and well, as just an open bucket. You can put assets inside of the bucket, take assets out of the bucket, and when you pass away, that's what this dotted line denotes, then that open bucket now becomes a closed bucket, because that solid line means that your trust now is irrevocable. And so there's an administrative phase that we have to get through, which I'll explain in the next slide. And then after that administration is done, then the distributions can be made to the beneficiaries. And we do use protective trust shares. The majority of our clients have opted to use that, and it's really important that beneficiaries understand that the power of these protective trusts. The clients are doing it because they care about the beneficiaries, and it's not a trust issue against the beneficiary. So you just need to know how they work. They're great. I love it. I've got it for myself. So you just need to understand the rules of the game. So administrative trust. First of all, the first thing that we do is build an inventory of all the assets. Traditionally, that is the most time-intensive part of the settlements, and that is where if we've done our job, and if our clients have updated their asset review reports and done their job, that should not take me that long. We use what's called an asset review report, and that would lay out all the items, and so I don't have to play Sherlock Holmes to go find everything, and that's traditionally what has caused a lot of expense and administration for these settlements. And so our settlement coordinator, Wendy Masimer, if there's a death occurs, will spend a lot of her time and a lot of the firm's resources in that first 3 months, but we don't have to go over that time if we've got a great inventory of the assets. So it's really critical that you keep your asset review report updated and really communicate with the firm on that. If I can just hit a button, know where everything is at, that saves us a lot of time and money for you. Secure valuations on all the assets. So the IRS wants to know exactly when you pass away, exactly what you passed away with. So that's the time when we would secure appraisals for you, make sure that we've got letters out to the banks and the various investment authorities. And so we want to make sure that those things are being done. Settle, like we discussed before, settle life insurance claims, annuity claims, make sure that we address the issues regarding qualified retirement plans. Again, I know the lingo out there, not sure if everyone is aware of it, but just want to make sure you understand qualified retirement plans are those plans that are in IRAs, 401ks, TSPs, so anything that's in a tax-sheltered account are called retirement qualified money. Then we would identify, negotiate, and pay the final expenses and debts, and then track the income. So we need your help with that, but we'll manage that process. Oops. The administrative trust, then the final income tax returns will be prepared. We would work with your CPA on that and help collect the information for that. We'll prepare any applicable estate tax returns. It seems like Congress makes my job harder now. In a separate program, we talk about the estate taxes and with portability. When I didn't have to file estate tax returns, now we have to file them more routinely for clients because of the portability option. That discussion is beyond the scope of this presentation, but we do have education programs on that. And then we want to educate the beneficiaries. It's really critical because there's really powerful protections in the trusts that our clients provide for the beneficiaries, and we want to make sure you understand how those work so that you can understand and make the most out of those protective trusts. And then we do the asset transfer process. Time expectations. Like I said before, the majority of the work is done in the first 3 months. But because of that alternate valuation date, we've got 6 months, but there's time to be taken care of afterwards as well to make sure taxes and the like. So the expectations should be between 3 to 12 months as far as the administrative trust is concerned. At that, we have routine meetings, and usually the first one's an in-person meeting, and then we just block certain settlement times for settlement calls and conference calls. Now, the initial settlement meeting, if you're not local, and we do have, with the power of technology, as we have done it today, we have a way to conference you in, and so we can absolutely do that if you're not present physically. But after that initial one, we'll do calls, and the calls are usually closer together in the first month or two of settlement, and then we spread them out a little bit more, but it just keeps everyone on track, and we find that with the process, it produces predictable results and makes things a lot easier for all parties involved. Trustees, just to give you a background on the parties to a trust. So there are 3 parties to a trust. Number 1 is the trust maker, the one who created the trust. Number 2, the trustees, the people who will manage the trust, pay the bills of the trust, manage the investments of the trust. And then the beneficiaries, those people who receive the benefits of the trust. In our trust documents, the legal documents, for married couples, those people who are listed as trustees are in Article 15, and those who are single are listed in Article 12. Our single clients have 3 less articles in their trust because of tax planning provisions that apply to married couples. The trustees will then, who are named, will assume complete financial control of the trust assets on the death of the trust maker, and they will serve subject to the instructions laid out into the trust. They have a fiduciary responsibility to manage those trust assets for the beneficiaries. Okay, there's 3 types of distributions. Initially, we want to take care of first the special stuff. And that's the special stuff list is what we call it. And I make a joke with the clients. There's 2 sets of special stuff. One is your special stuff and then your junk. We want to make sure that we have a good list on the special stuff, because I find that if there are disagreements between the beneficiaries, it's not over the big investment account. It's maybe over mom's Hummel collection or dad's barbecue. And I'd hate to have a situation where the family, the clients have put a lot of thought and effort, and the firm has, to make the plan really work and make life easier for the loved ones during a difficult time, and put all these protections in, but then we've got hurt feelings because of miscommunication. And so we really want to, and I'll hit on this issue a little bit more, but really encourage our clients to make sure that they address those special stuff. So the next is specific distributions. Those are listed in Article 7. And then the final one is percentage distributions. Those are listed in Article 9 for our single clients and Article 12 for our married clients. So let me just go back to special stuff again. It basically provides a list of items to be distributed before any other assets. And typically the items have sentimental value, and you identify who you'd want to have those assets. And they're behind in the red estate planning portfolios. They're behind the personal effects tab. Not all clients complete the special stuff list, and so that's what I'm trying to avoid, is any type of disagreements or hurt feelings on that end. And I also find that the best gifts I had, where there was some there's also a note or a thought behind it, and I really think that this is an opportunity to capture one opportunity to capture your legacy, talk about what that really meant to you, what that personal effect meant to you, and maybe who gave it to you. I have a very special ring that I have that it took a lot of work. It's a championship ring, and went through a lot of hard work to get to it. And I would just want someone to have that story that would go along with that ring. I think it just makes it that much more powerful. Okay. The next distribution, after we get the personal effects and the special stuff distributed, the next is what we call the Article 7 specific distributions. These are specific, maybe cash bequests. I want $10,000 to go to this nephew or this niece or this church. We want this car to go to this person. So we want to just make sure that those specific bequests or specific distributions are honored at that point in time. Then finally, after that, is percentage distributions or the residual distributions. And for our single clients, those are laid out in Article 9. For couples, we have that laid out in Article 12. And whatever is remaining in the trust at that point in time is divided into the beneficiary's separate trust shares at that point in time. And so now, again, I really want to go into it. Our clients have put a lot of thought into this. We've worked with our clients on it, and we can put significant trust protections for the beneficiaries if they manage the trust properly. And so we need to be educating the beneficiaries, and if you're listening to this type of program, you're on the right track. But we are developing an education program to go into more of the details. And so we want to make sure that not only our clients are listening to this program, but the beneficiaries are, and we encourage, we want to make sure that our clients understand that they need to tell the beneficiaries or ask the beneficiaries to listen to our upcoming programs, what I call on wealth reception, and make sure that they're comfortable, they understand how these work. And I'd rather that if there's any questions, that we get those questions answered now rather than later. And I want to have a relationship and that they know who the law firm is. So some of the protections, for example, that you can use that if the trust is being managed properly is catastrophic illness protection. Let's say that a beneficiary gets hit by the school bus and is now on government assistance. Well, government assistance under the current law to achieve or to be able to obtain government assistance to get things like Medicaid, you have to basically spend down all your assets. Well, we can put catastrophic illness protection provisions into the trust where those assets would not have to be spent down, and those could be protected. They could actually supplement government assistance. Catastrophic creditor protection, another big protection that is there. And so I call this the school bus story. Let's say one of the beneficiaries, after you pass away, they hit the school bus, and now there's a judgment against them, your hard-earned wealth could just be taken away, and we want to make sure that they understand the power of these trusts. So we can build in protections like those school bus protections that if you were to get sued, and if you think about it this way, well, if you were to get sued, that you can have a high level of creditor protection against those types of creditors. Divorce protection, let's say a beneficiary were to get married, or just married then divorced, or just divorced, then we can put a high degree of protection to segregate those assets from any type of divorce proceedings that normally everything gets divided pretty much 50-50. So we would want to segregate that so those assets that you leave to your beneficiaries stays with them. Bloodline protection, assets that stay in the bloodline, that's self-explanatory, just goes to the next generation. And then also values promotion, kind of that legacy planning, that non-material wealth, the life lessons, the stories, what's been the best investment experience, best investment you ever made, the worst investment. So those teachings are important too, and they can be built into the trust if the clients opt for that. Okay, for beneficiaries, it's really critical that you understand how a protective trust works. So I used to be a plaintiff's attorney, and the way it works, if we were to get a judgment against you, so let's say you hit the school bus and there's a judgment against you, basically what happens is the creditor can step into your shoes and can access any assets that you can access yourself. And so the way that the protective trust works, if you're the only beneficiary of the trust and the only trustee, then if I was a creditor, I would step into your shoes and I would say, I know the trust says that you have all these great protections, but you're the only trustee, and I order and I demand to take that money out and distribute it out. And the judge will probably authorize that. However, if you had a co-trustee, an independent co-trustee, someone who's not related by blood or marriage, then you have a higher degree of creditor protection where you're not the only person there. And you'd have to say, well, to the creditor, I'm not the only person responsible for making this type of call. You have to ask my co-trustee here, and good luck getting them to do it because the trust says they're not supposed to do it. So a higher degree. So you just need to understand how the trust works and how to maximize that. As far as the administration and the investment provisions, that's all counseling, and that is done on a client-specific basis. But we've definitely determined how that works, and we will do future programs, and that's part of our wealth reception planning program, on how to maximize that and how to be able to access those assets with a high degree of flexibility for you and comfort. So that's the main thing that we want to make sure that you understand and we want to get you educated on. The Helper Handbook. So we're going to go back into the Helper's Handbook again, and so the Trust Settlement Instruction tabs contains a lot of detailed information. I'm not going to go through all that. But it also goes through some frequently asked questions that we find a lot. We get asked a lot. So before you call a law firm, we have some questions that we've seen before that may have been answered already in this book. So you really want to go to the Helper's Handbook. But you'll see tab 8 of the Helper's Handbook is frequently asked questions section. And so what should you do? What's the first thing to do? Definitely call the law firm. Second thing you should do, you want to make sure that you look at the final arrangements. The last thing I want is that clients have taken a great amount of time to make sure that we've got the final arrangements laid out, make it easier for the family, and then you don't look at the final arrangements. So make sure you look at the final arrangements. Anything you need to do with regard to the funeral director, we'll just see if there's any type of prepaid funeral plans that are in place as well. And if they've done their final arrangement instruction checklist, then that should be covered. A lot of our clients, some of our clients don't do the final arrangements. Strongly encourage them to do that. It makes things a lot easier. How should I pay for funeral expenses? Again, we talked about that. We can get the trust assets released fairly quickly, or at least the successor trustees listed quickly, or if the funeral home wants a verification of assets, we'd be happy to provide it to them. How How many death certificates should I order? Normally a good rule of thumb is 10, and we would let you know as well. It just depends on the number of assets that are out there, but 10 is usually a good number. We told you before that don't drive the decedent's car. Again, liability exposure. If you do that, we can get the decedent's car out fairly quickly, so please don't drive the decedent's car. Also, removing the household furnishing. Again, just logistics. So a lot of these things you're looking at, we want to make sure that you see these. So these are just some questions that we have found over and over again. And so just look at that, take a quick look at it, and move on. Resources. Okay, so back into the Helper's Handbook. We don't want to be, of course, we're going to take care of the legal issues, but we really view ourselves as counselors, and so there's a lot of other issues, not only just legal issues, but emotional and financial issues that are involved when a death occurs, and so we just want to make sure that we have done some vetting of the various resource partners out there. And so we want to make sure that you know who we like, and that you have a leg up on that, and you can do your own due diligence. For those clients who are not local to the Washington metropolitan area, we have colleagues in different jurisdictions have done similar vetting. So just let us know, give us a call at the firm, and we will get you their state-specific list of resources. But I'm just going to kind of scroll. I'm going to scroll down slowly on these, so you just see some of the things like hospice, home services, just getting things organized with the house, retirement communities, funeral homes, funeral services, bereavement services, helpful books. We did a program just the last night, a survivor support program for our widows and widowers, and we got some comments that some of the books that we had were good, and so we're hoping that, and if there are other books that any of our clients have read, we're always looking to do that, but we're vetting this as well. Here are some good books that are out there in the various topics. Okay, and then also another item is just a glossary of legal terms. This we're going to be updating soon, so and we will get that up on the website, and that's another reason why, and I mentioned this later, that you do want to have do this or listen to this program again, especially if you're a helper or beneficiary, at least every 3 years, because we are constantly updating things, and laws are changing, new techniques are being introduced. But things like, if we're using the name like RLT, is an acronym that stands for Revocable Living Trust. So things like that, just to make your life a little bit easier, and so you don't get overwhelmed with all the legalese that is out there. Okay, again, I have to just do one item. Okay. Sorry. Okay. So, proactive lifetime steps, really, really important. Okay, so like I told you before, fully funding your trust is a huge time saver for us, and also saves a lot of expense on your part as well. If you do not have a fully funded trust, and what that means is, remember, the trust is just an open box, and you put all of your assets into the box. We put the majority of the assets in. Sometimes we wouldn't put, let's say, an IRA or qualified plan into the trust. We actually, those are contracts, and we make sure that they're payable to the trust in some manner. So we've gone through that with our clients, but if we struggle, we want to make sure that if you don't have verifications, we don't have verifications on all of those assets, and Wendy's our funding coordinator, and we routinely send out funding action items. But if the trust is fully funded, I just hit a button. It saves us a lot of time and energy on that. If assets are not titled properly, they could potentially go through probate and frustrate the plan. And so we have made a commitment to do everything that we can on our end. But if you're not disclosing everything to us, or not doing the follow-up work that we're requesting, we're not responsible for that. So it's a team effort on that end. Number 2, complete this. And if you're complete the special stuff list. Again, I mentioned that before. Don't think I need to mention it again. Communicate the what to do steps now. So I just find that it's better to be proactive than reactive. The thought is, I use my example of the Lucille Ball story. If you remember the Lucille Ball episode where Lucy and Ethel are at the chocolate factory, and the chocolate factory conveyor belt's going really slow at first, and Lucy and Ethel, their job is to wrap the chocolate. Well, yeah, the manager comes in and says, "How you doing?" Right? And we're doing great. Great. Speed it up. And they speeded up the conveyor belt. Well, Lucy and Ethel didn't do too well, right, when the conveyor belt moved faster. They were eating the chocolate, putting it in their hat, stuffing it down their shirts. And so, you know, I find that in comedy there's a kernel of truth that makes it that's universal, that makes it funny for everyone. And I thought that in that episode that the universal kernel of truth is people don't learn well under stress. And so what can be a more stressful time in a loved one's life than when a loved one passes away? And so that is not when I want to be doing the education for the beneficiaries or the helpers at that time. You know, and that's why the traditional process is more expensive on the administration side and takes longer, is because things are not sinking in at that time. There's grieving going on, not with a lot of emotions. So what we do is we thought, why don't we do the education like now before something happens, and do it through webinars or in group format to keep the cost down. So that's the idea, and I'm going to ask all of the our clients to require the beneficiaries to listen to this program, and also as we do future beneficiary training programs and wealth perception programs, that they attend those as well, and that you attend those as well if you are a beneficiary. It's the right thing to do. It's going to make everyone's life easier and maximize the inheritances and the protections that are associated with it. And so we're just really committed to doing a plan that works, and I just find having a great relationship with the parties makes things smoother for everyone. And I'm not such a bad guy. Okay, so next is complete the location list. So in the red books, the red binders that have the legal documents, there's a tab called location list. And so again, just, you know, where are the business papers, investment accounts, bills? Where do we keep all of those things? That is really critical. It saves a lot of time for the family because organization really helps save a lot of time. With passwords that are out there, I don't know about you, I've got about 120 different passwords for the various online accounts, and so that could be it's a huge issue. And what we have created is called a digital executor, and it's usually the trustee that has the access, but that is only as good as them being able to know what your passwords are. And so there's a couple ways you can do it. I've seen it done many ways, is that at least let them know if something does happen where that list is at so they can access that list. And the alternative, we use a service called DocuBank. And DocuBank traditionally has only been used for medical directives, and that's when if there's a mental disability or a health issue, and that's where the documents are stored. The healthcare documents are stored because most people are, it's digitally stored because people aren't really trying to, you don't want to be scrambling around trying to find these directives if something happens. And so they have also offered a service called DocuBank Safe, where it's a separate portal that you go to in DocuBank, and that is where you can store all of your passwords so that your helpers could access that at the appropriate time. I go into DocuBank in more detail in the program, What to Do When a Loved One Becomes Disabled, so go ahead and listen to that program. And also we have a DocuBank video on the website and portal access as well. Their website is very user-friendly. Their staff is really friendly as well, and you can give them a call too. All of the information is on our website through our client portal. Keep the law firm updated on helpers information and beneficiaries information, addresses, names, email addresses, contact information. I don't have to go finding all those people. Then that makes my life a lot easier too. And then complete the final instructions memorandum. Makes life a lot easier for the family members. So if you haven't completed one of those yet, please do it. You don't have to do every line of it. We find in our firm it's easier to edit than to create, and so just use what you need from it and document it and let us have a copy of it so that we have it on file as well. Okay, closing comments. As I stated before, we want you to attend this meeting at least every 3 years because things do change. So please do that, and we will make sure that we get your attendance and let us know about the attendance because we keep track of that. Part of the reduced settlement fee on the back end applies to those families who have actually completed the training, so that is a requirement to do that. We have also, if you are someone who's not a client of the firm listening to this and aren't interested in doing estate planning, we do client orientation workshops or client orientation meetings once a month. It's the second Wednesday of each month currently. You can contact the firm or go on the website and register one of those programs. It's no charge for the program. It goes through our process, our philosophy, different fee options. And with that being said, I'm just going to check to see if there's any questions from our live audience, and we will see if we need to address any of those issues. But really want to thank you all for coming. It is a great first step on this, and to make sure that you know who the law firm is, our process, and how the settlement process works in general. So let me check and see if there's any other questions or any questions. Okay, I guess I've just I've hit every issue, and so thank you very much for your time. If you do have questions, if you've listened to this program not on a live format, feel free to contact the law firm. We do not charge hourly. That's not part of the game here. We believe in clear communication, and so we're not going to nickel and dime you on that. If there's a question, concern, or issue, I'd rather have that addressed, and hopefully that'll give you some peace of mind. Again, thank you very much for coming. My name is Bobby Fazy. I'm president of Insight Law. I'm the estate planning attorney, lead estate planning attorney here, and thank you very much for your time.